It is May 23rd of 2026, and this is the Court Gallery. Some days in court are routine, and some days you get this. Today's docket is packed with individuals who just can't seem to get out of their own way. First up, a man with thousands in child support arrears tries to explain why he can't even pay $12 a month, but Judge Mogen is not having it. Then a woman attends her hearing for driving without a license by driving herself to courthouse without a license. And you'll want to stick around for a workplace drama so intense it spills over from HR into a PPO hearing, with receipts being read live in court. From runaway horses to unbelievable excuses, we've got some crazy cases to review today, and it all starts right now.
We will go on the record in the matter 18 FA 83, State of Wisconsin, OBO, NCM. Appearances are, we do have David Misch Jr. appearing by video conferencing in custody in Trempealeau County Jail. He is appearing by Zoom. We are here for the motion hearing. Mr. Misch has been in custody for a significant amount of time. I'm not even sure how long, but has it been a year?
No, Your Honor. Historically, Mr. Misch was in court, was not in court, August 13th of 2025, where he was found in contempt, given a review hearing of October 8th, where he again did not appear. Interestingly enough, at that October date, there was not a finding of contempt made, though there had previously been a finding of contempt where he was under the purge. He didn't appear in October. He was given a January 14th date where he was required to appear at minimum telephonically. He again did not appear. Finally, a warrant was issued. Mr. Misch was arrested at the end of January on new charges in Trempealeau County, which is what he's been in custody on since. He is on a cash bond. Most recent review of CCAP indicates that that is a $1,500 cash bond, and they are very significant charges.
Okay. So he requested to appear by video conferencing. Court allowed it simply so we can see where we are with regards to this child support matter. What are you looking at doing here, Ms. Thomas-Schmidt?
I suppose I don't have an objection to quashing the warrant. We have filed at one point for sanctions. Those sanctions have not been issued in part because Mr. Misch chooses not to appear.
And wowza, I'm taking judicial notice of Trempealeau County 26 CF12, as well as 25 CF159, excuse me, it's 26 CF12 and 25 CF159. You are correct. Very serious allegations in the 26 case. Possession with intent greater than 50 grams, OWI 5th or 6th, felony bail, and operating while revoked. And he's only on a $1,500 cash bond.
Correct. But I guess they do things, that's how they do things in Trempealeau. With regards to compliance with child support, the August hearing, which Mr. Misch chose not to appear for, his conditions were to pay $20 a month, to provide a release so that we can obtain information regarding his alleged medical issues, an update on his Social Security application process, and supporting documentation from his doctor on his inability to work. Whatever it was that existed, that was provided to Social Security. Mr. Mish has done none of those things. Procedurally, it's not exactly clear to me if the review hearings in October and January that Mr. Mish chose not to appear were simply to extend his purge, modify conditions, or if they were to impose sanctions, given that procedural confusion. I guess my request would be to extend Mr. Mish's purge, beginning the first of the month following his release from his current incarceration for a period of 12 months. That Mr. Mish be required to notify child support of his release from incarceration within 7 days, so within 1 week, that he email or call or write a letter to the Burnett County Child Support Agency regarding his change in incarceration status and residence. And that the other conditions remain in effect, that he pay $20 per month, which is frankly incredibly minimal, that he provide updates regarding his medical condition and ability to work with any medical documentation that may exist for that, and that he signed a release.
I get where you're going with all of these things. Quite honestly, I don't think any of it's necessary right now. When I'm looking at the Trumpeau County case, those are very serious charges. Granted, he was on a cash bail until March 3rd, 2026 of $7,500. It has now been reduced as of that March 6th date down to the $1,500. He still hasn't posted $1,500. It doesn't look like he's going to be able to post. The only thing that the court would state is necessary at this time is that there's a mandatory update to the Burnett County Child Support if and when he is released from custody. These are serious cases. The OWI-5 has a mandatory minimum of 1.5 years in custody if he is convicted of an OWI-5. And quite honestly, I think it's just going to be a waste of time and money and putting ink on paper if he's going to still be in custody.
I suppose my concern is if there's a period of time where he's out of custody.
And if there is, then that's an must be in-person appearance. Because we need to see him. He hasn't been present in the court in well over 1 year. Granted, This is a transfer from a California case, I believe.
I believe it is California that asked us to enforce.
So here's what I want to do. I agree with all of the things you're saying, but there's no way he's going to do any of them until he's at least released.
Right.
And so, Mr. Mish, what I'm ordering you here today is that when you are released from custody, if you are released from custody, that you must notify the Burnett County Child Support Agency immediately. Immediately doesn't mean 2 days. It doesn't mean 1 day. It means immediately. You pick up the telephone, you give them a call, and you say, I have now been released from custody. And while on that call, they can give you a court date where you will mandatorily be required to be here in person. So we can go over all of the things and get updated as to your Trumpeau cases, as well as your ability to work, if you have the ability to work and or receive Social Security. Understood?
Ma'am, now if I may, a lot of things happened during, my dad passed away. I don't
want nor need to hear your excuses.
Well,
okay.
This is all old stuff.
I don't. Stop. Don't call me ma'am, and stop.
Yes, ma'am. Okay, yes, ma'am.
This is not your time to tell me why you can't even afford to pay $20 a month to go towards, paying for your children that you created. So.
You're right. You're absolutely right.
So once you are released, if you do become released from custody before conclusion of these cases, you must immediately notify the Burnett County Child Support. They will give you a date and time to be here in person, at which time I will be more than open to hear excuses as to why you weren't able to pay $20 a month. And we will go from there and we will set new requirements and or a potential possibility of jail.
Yes, ma'am.
Anything further?
Just for my clarification, should this be ordered as under the heading of a contempt order or as a separate order?
A contempt.
Okay.
All right, if that's all, please notify them immediately if you are released, Mr. Mish.
All right, so the warrant is gonna be lifted then?
The warrant at this time, so that's probably why he hasn't posted either. That's probably a good reason why he hasn't posted.
Well,
If you
I'm trying to get things figured out, so maybe I can make things work for all of us. Yes, ma'am, I'm trying.
Well, it better work for all of us, and I'm gonna tell you, it's gonna mean more than $20 a month in payment. What his total arrears, it's not that high. I believe it's like $3,000. It's not totally.
When you, about 2,600, yeah.
So 2,600.
I want to pay you guys more than anything. Believe me, I want it done and over with. I paid all my life. All my life I have paid child support. And it's not like I owe thousands and thousands of dollars. They're my kids. Yes, I will pay. But you just got to give me a chance here. I've been through a rough spot here this past 6-8 months. Ever since Dad passed away, it's been a bad spot for me. And I apologize to you guys for all this, everything that has happened. I do apologize.
I understand the passing of a parent, but you put yourself in this bad spot, Mr. Mish.
Well, I took care of him for 3 years and I literally watched him pass away. It did something.
And that didn't cause you to have allegations of your Trempealeau County cases.
No, it
So
didn't.
you put yourself in the bad spot.
Yes, ma'am, I did. Things just got out of control, I admit.
All right, well, it looks a little bit more likely that he's going to be able to pay now that this warrant is quashed, and so be expecting a call. And Mr. Mish, if we find out that you're released or the child support finds out that you're released and you haven't contacted them to get a new court date, believe me, that's when the warrant will be issued right away.
I will contact you. I promise you I will.
All right. We are adjourned.
Thank you.
We will go on the record in the matter 25 CM 145, 25 TR 489, State of Wisconsin versus Alex Coleman. The state appears through District Attorney Kevin Schmidt in person. Bruce Anderson, Defense Counsel, appears in person. Mr. Coleman appears by video conferencing. We're set today in this matter for a status. I know that he had the Polk County matters and things, and that it didn't look like this was going to be something that could be worked in. Please update the court, Mr. Anderson.
Judge, Polk County is not going to be able to work in with this one. I received a proposal from Mr. Schmidt. We're in 25 CM 145, which is a charge of going armed while intoxicated, I believe is the statute. And excuse me, that's going to be read in and dismissed. My client will enter a plea of no contest to a charge of operating a motor vehicle while intoxicated. First offense. Mr. Schmidt has asked for $999.50 with lowest guidelines and aggravated driving. I would like to be able to argue relative to the length of revocation. I believe the alcohol content would not require an IID. I believe that's where we stand. He'll need time to pay. Don't think we have any observed aggravated driving.
So it was just, that was the agreement for the dismissal of the operating a firearm while intoxicated?
Yep, and then we'd be doing the aggravated guidelines, but he wants to argue the rev period.
I couldn't understand.
Yes, exactly what you said.
Sorry, I'll speak more into the microphone.
Okay, all right, and he wishes to do that here today?
Yes,
And his BAC
085.
085. Okay. All right, and Mr. Coleman, you understand everything that's been stated on the record by your attorney?
What was that? I heard a 99.50. What was that?
That's the fee. The $999.50 is the statutory fee for
Okay.
aggravated driving OWI first.
Okay.
Okay, plus a $10 blood draw fee.
Okay.
All right, and that's what you wish to do, Mr. Coleman? You wish to accept that offer and plead guilty to a forfeiture, OWI first, aggravated driving, and have the other matter dismissed and read in?
Yes, Your Honor.
All right, so,
the aggravated driving
Yeah.
is what I wish to argue.
oh, well, then we're gonna do it a different day.
Can I ask a
Because
question
then-
about that?
Then this isn't an agreement then. So is this an agreement or is it not an agreement?
If we want to argue whether it's ag guidelines or not, that's fine with me. The difference is $50 and 1 month license revocation.
And I don't think that there is another modifier to add aggravated.
Aggravated just reflects what the 10th Judicial District does for guidelines. It has no statutory meaning.
I didn't believe it did, so I guess if it's not going to be a long-winded argument, we could have an argument here today, but Mr. Coleman had a question. Is that a question for the court or is it a question you need to talk to your attorney about?
I was just kind of confused. It was like the court. I was kind of confused how it's aggravated drive. I was sleeping in my car. So I'm
Okay.
confused where the aggravated driving comes from.
The aggravated is coming from the discussions from the state of Wisconsin, the district attorney to your attorney to say, as part of the deal, they're going to dismiss that operating a firearm while intoxicated, but the state would like to
Oh, I
argue the aggravated driving because of the dismissal of that other charge.
Okay.
And so your attorney wants to argue to the court whether or not that should be applicable. So do you understand everything now?
Yep, I'm caught up.
And with that understanding, you do wish to move forward and enter a guilty plea for the OWI first.
I believe so. That's what I believe me and my lawyer talked about. Yeah, I believe so.
Yes, so you do. So he wishes to enter a guilty plea, correct?
Yes,
Guilty will be entered on your behalf as it relates to the OWI first. We'll dismiss and read in 25 CM 145 argument as to whether the court should count it as aggravated or not aggravated. Mr. Schmidt.
So this is a low blood alcohol concentration. What I thought was aggravating in this and also mitigating in other ways is this arose out of a concern of Mr. Coleman being suicidal. The concern was a significant other had called it in. He was known to carry a firearm on his person at all times, and when he was arrested at the vehicle, he had the firearm. I don't know how things have gone with mental health in the meantime, but for here, the state would just ask for aggravated guidelines for that purpose. Thank you.
Mr. Anderson.
Judge, I guess the aggravation, if you will, as far as driving, this took place at the Bass Lake Lumber Facility, which is near Polk County. And he had been in Frederick with his girlfriend when he left there and talked to her on the phone. Geographically, any bad driving likely took place within the county of Polk. He then pulls into the parking lot of Bass Lake Lumber and proceeds to fall asleep there, and is contacted by various law enforcement officials and so on. It's not like he was waving the gun around or anything like that. He was pretty much sleeping. He wasn't highly intoxicated. The test result, I believe, came in at 0.085. All we're trying to do is minimize the amount of time that Alex is going to be without a driver's license. He has gone through significant counseling with programs for change in the health partner system through Amory Hospital, and both psychological, mental health, as well as alcohol use. So just trying to get things going in the right direction. He knows he's going to be without a license. He will have to get an occupational for a minimum of 6 months. He's not served any time under an administrative review suspension for reasons unknown to me, but certainly law enforcement could have, but didn't send that in. But just trying to cut it down to a 6-month suspension or revocation rather, so we can start getting other things on in his life instead of a 7-month.
All right. Mr. Coleman, anything you want to add or you want to let me know?
I just want to clarify. I do my counseling at Aurora now. I don't do Amory. I had an insurance problem, so now I switched over to Aurora, but it's still everything he stated. I'm still doing there.
Good. I'm really glad to hear that, Mr. Coleman. It sounds like you were having a really, really bad time. It was a low period in your life, and it sounds like you were taking it seriously and to be harmful to yourself, not necessarily to others. I understand the argument for the aggravated as being tried to be worked into the agreement, because that misdemeanor crime of operating a firearm while intoxicated, that is serious, because even though you were at the lower end of 0.085, you were still intoxicated and you still had a firearm. And so that still makes it more dangerous. As to operating, you were sleeping in the car. You had the ability to actually operate the vehicle if you wish to do so with your intoxicated state. What I am going to do is I'm going to order the $999.50 fines and fees plus the $10 blood draw fee. And I'm going to I'm going to do 6 months of the revocation of your driver's license, because I think you're doing the work you need to do. And so it's a month off for you to make sure that you can get your occupational. You have to do your OWI assessment and that driver safety plan and get that all done as quickly as you practically can. This is 6 points off of your license. When will you be able to have that fine and fees and surcharges paid?
Does it need to be paid in full, or can I start up a payment plan?
I can give you a payment plan, $250 a month, and first
Probably make
payment
that
by the end of the month. Does that work?
Yeah, I'll make that work.
Okay, you can set this up by a wage assignment if you wish and have it taken out out of your check. Just when we're done, call the Burnett County Clerk's office and tell them where you work, give them that information, and they can make sure that gets taken care of. Then you'll never miss a payment. Because if you fail to pay even 1 month, the court will issue a warrant and you could sit up to 6 months in jail, okay? And
how many days do I technically have to go get, because I can go get an occupational, correct?
You would be able to go get an occupational after you complete your OWI assessment and that driver safety plan. And then you have to go to the DMV and they're the ones in control of exactly when you would be able to get that license.
Perfect. Okay.
Okay. All right. Don't forget a payment.
I won't.
We're adjourned.
Thank you guys. Have a good week.
We'll talk.
We will go on the record in the matters 25 CM 100, 25 CM 134, 26 CM 39, State of Wisconsin versus Ronald Ritchie. We also have a group file 26 GF85. Is that not being charged?
Not being charged at this time. It looks like the police are going to be doing forensics. So we're just resolving these cases. If and when that case gets charged, if it ever does, we'll deal with it then.
All right, so then he's currently on $1,000 cash. With that, what would you be requesting of the court?
We can just release that, especially since the disposition today involves probation.
All right, okay, so the court will cancel the $1,000 cash component to the 26 GF85. There will be no, I'm gonna actually cancel all of the bail completely. No bond, no bail. We'll wait to see if that is going to be charged. All right, then as to the other matter, what is the agreement that's been reached?
The offer, Your Honor, would be to plead guilty to THC and 25 CM 100 and plead guilty to misdemeanor bail jump in 26 CM 139, dismiss and read in all other charges, and case 25 CM 134. And this would resolve in DNA surcharges, 1 year of probation, AODA, and follow through.
All right, but it does not impact or affect the 26 GF matter, correct?
Correct.
Mr. Ritchie, I have in front of me the plea questionnaire waiver of rights form. Do you recognize the document?
Yes, ma'am.
Did your attorney go over this document with you thoroughly,
Yes, ma'am.
word for word?
Yes, ma'am.
You understand everything on this document?
Yes.
If by chance you did not understand something, did you have your attorney explain it until you thoroughly did?
Yes, ma'am.
So you're telling the court you do understand everything.
Yes.
You're pleading guilty to 1 count of possession of THC in 25 CM 100 and 1 count of misdemeanor bail jumping in 26 CM 39. You're 36, 12 years of schooling. You can read, write, you understand the English language, and your attorney thoroughly went over what the state would have to prove your guilt beyond a reasonable doubt, correct?
Yes, ma'am.
And your attorney thoroughly went over with you the maximum possible penalties you face.
Yes.
You are receiving treatment for a mental illness or disorder, and you've had medications, correct?
Yeah, I take medication every night now.
And you're taking it as prescribed?
Yes, ma'am.
Does it interfere with your ability to comprehend or understand things?
No, it helps a lot, actually.
Well, that's good. So you're in a state of being where you are understanding and comprehending everything?
Yes, ma'am.
Do you understand your constitutional rights?
Yes.
Your attorney thoroughly went over those with you?
Yes, ma'am.
Do I need to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
Do you understand the state would have to prove on or around June 28th, 2025, that you possessed a substance, the substance was a controlled substance, THC, and you knew or believed that substance was a controlled substance, THC?
Yes, ma'am.
You understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $1,000 or 6 months of incarceration or both?
Yes, ma'am.
Do you understand in 26 CM 39, the state would have to prove on or around February 16, 2026 in Burnett County, Wisconsin, having been charged with a misdemeanor in Burnett County case number 25 CM 100 and having been released from custody, you intentionally failed to comply with the terms of your bond by committing a new crime? Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes, ma'am.
Do you further understand that there is an agreement here where the court would be, it would be recommended to the court to place you on probation with certain conditions? Do you understand I'm not bound to follow that?
Yes.
Said differently, I could sentence you all the way up to the maximum possible penalty for all of these crimes if I thought it was warranted. You understand that?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
I do.
Did you go over the criminal complaints with your attorney?
Yes.
In particular, the sections where it basically says what happened that day and why you were charged with the crimes?
Yes, ma'am.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty to possession of THC because you are guilty of possessing it?
Yes, ma'am.
Are you pleading guilty to misdemeanor bail jumping because you are guilty of violating intentionally your bail and bond conditions
Yes, ma'am.
and that you committed a new crime?
Yes.
Ms. Sherwood, may the court use the probable cause section with the statements made by your client to find a factual basis?
You may, Your Honor.
Has anyone made any threats or promises to you, Mr. Ritchie, for you to plead guilty to these charges?
No, ma'am.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
I do.
and voluntarily.
Yes, ma'am.
Has your attorney represented you competently?
She's phenomenal.
She's answered all your questions
Yes, ma'am.
and she's looked at these matters thoroughly,
Yes,
and you're satisfied with her services.
I am.
Any questions for the court or for your attorney before I proceed?
No, ma'am.
As to count 2 and 26 CM39 misdemeanor bail jumping, how do you wish to plead?
Guilty.
As to count 1 in 25 CM 100 possession of THC, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those charges. The remaining open charges, excluding 26 GF 85, will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
The 25 file involved on a traffic stop, Mr. Ritchie being asked to hand the title, and the title just had loose THC on it. While on bond, he was found in possession of paraphernalia, quite a bit of it, and some of it tested positive for fentanyl. Even though paraphernalia is a lesser charge in terms of maximum penalty compared to THC, I think the fentanyl is more concerning. So weirdly, I would say the paraphernalia case is what drives most of the state's concern, which is it's dangerous and we want him to get sober and maintain sobriety, which takes time, hence the 1-year probation disposition. So we'd ask the court to follow that so that he can get AODA and follow through. Thank you.
Ms. Sherwood.
Yes, Your Honor, we're asking that you follow the joint recommendation. Mr. Ritchie has, as Your Honor knows, been struggling a little bit the most recent history. However, Mr. Ritchie is now getting the help he needs. He has told Your Honor he is currently getting mental health treatment in the jail, something he would very much like to continue outside of the jail. He will be getting help with his addiction with AODA and a follow through. And with the 1 year of support, he can get his life back on track so nothing like this happens again, Your Honor. So we're asking you to follow the recommendation. Thank you.
All right, Mr. Ritchie,
Yes, ma'am.
anything you want to add, you want to say?
No, ma'am. Everything that's completely accurate. I have full intentions of seeking AODA and other forms of treatment. I've been taking AA classes in jail and all that, and even that has helped a lot.
I am glad to hear that. This past year or two with you, Mr. Ritchie,
Yes, ma'am. It's been rough.
it's been a continuous cycle. You've been in and out of these doors. I don't even know if I can count how many times.
Too many to count.
Too many to count.
Yes, ma'am.
I don't know what's going on. You were doing well for this little brief period of time, and I want to see you go back to that.
A little bit of trouble upon losing my job, but I've already got another plan for a new job, and I'm not looking to repeat anything because clearly it don't work out for me.
Not working out,
No.
not very well.
So I'm pretty much set on AODA and treatment and stuff like that. I'd like to also start attending AA class or meetings and stuff.
You seem like a nice guy, Mr. Ritchie, but you're making some really dumb choices.
That I am. I'm aware.
You're not going to be able to get your life back on track and do what you want and be what you want until you really take control of your sobriety.
I want to be better and I will be better. And I'm not leaving myself in any other option.
Well, I'm glad to hear that. This is serious. It's more serious than it looks on black and white as described by Mr. Schmidt. Fentanyl is extremely dangerous.
I was
You
unaware
could
of
die.
I was unaware of that, but no, I understand completely.
You were unaware that fentanyl is so dangerous?
No, that was in the mix there. I didn't know that.
Well, and I want to tell you that
It actually scares me.
it should scare you. I am not promoting any drug use and I don't want you to have any drug use, but for anyone who's not aware, they do make fentanyl strips where you can test to see if there's fentanyl in your substances, because otherwise you will die.
I didn't know that, but that shouldn't be an issue because unless it comes from my doctor, I'm not having no part of it.
I hope you take hold of that, Mr. Ritchie.
Yes, ma'am.
You're not a menace to society per se. You're more of a menace to yourself and your own life, and you're messing it all up.
I've had I guess a habit of being self-destructive, and I don't know why, but I plan to fix that.
All right, so I'm gonna follow the recommendation, 1 year of probation. I am going to order 6 months of jail imposed, but stayed per count, but concurrent to each other. So if you are revoked after probation, you're going right to jail, sitting time, okay? Conditions on probation, AODA assessment and follow through, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia.
Of course.
No medications without a prescription. No bars, taverns, liquor stores, casinos, or any establishment that has the primary purpose for the sale or the service of alcohol.
Haven't drank in 2 years.
Well, keep that one going. Regular substance testing.
Okay.
Continued mental health. So you have to figure out how to continue to do your mental health and engage in those.
I
services.
figured because I got meds at the jail here that I'd have to see a doctor in Webster and get the prescription.
That's my next one. Go see a primary care physician. I wasn't gonna order Webster or Siren or any other place.
I had one a couple years ago in Webster.
Go to your primary care physician,
Mhm.
Have an evaluation, take all of your medications as they are prescribed to you,
Yes, ma'am.
and gainful employment.
I hope so. Soon.
I hope so as well. $200 for the one charge. Honestly, you have a whole lot more of tickets that you owe a lot to, so I'm
remember.
only gonna do $200 per charge. I'm gonna waive the court costs and fees. Any other money that you may have outstanding in this case will go to pay towards your fines and fees, which are a lot.
I remember.
And so you're gonna have to get on that, because not only will the court enter a civil judgment, but I will issue a warrant, you will sit jail, and it will be consecutive to any other sentence or any jail that you may sit for this.
I understand.
So it's very important you find a job and you make your payments. I'm just gonna order that you make a payment plan with the clerk's office.
Right.
Because I don't know your total, but I do know it's a lot.
I was looking at some of the paperwork I had in the jail there, and it's a number.
Okay. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. The jail will make sure that they have that. You must report to probation immediately. I'm not sure you can get there today.
I was just gonna say, I
If
don't
you
know.
can't get there today, you have by 3 o'clock tomorrow,
Okay.
but you must report immediately. You must notify the clerk of an updated address if it's changed from the PO Box 125 Sturgeon Avenue.
So, well, the PO box is accurate, but the physical address isn't.
So we need to nix that.
Yeah. Well, right now, I don't know for sure if I still have an address, but it was 7720 Johnson Street in Siren.
All right, we'll change that. You must update the court every time your address changes within 48 hours.
Okay.
Telephone ends in 2351.
No,
Just update the court as soon as you have
I
one.
will. I don't remember what the number is offhand.
You must report again to probation immediately. Get that taken care of no later than 3 o'clock tomorrow. I think I went over everything, Mr. Schmidt.
Nothing further from me.
Nothing from the defense.
All right. Good luck, Mr. Ritchie.
Thank you.
Don't forget to call the clerk and set up your payment plan or stop by.
Yes, ma'am.
All right, thank you. We're adjourned.
And then we are on the record in the matter of the City of Riverview versus Colby Hess, 26457 A, B, and C, and then 26V4025 A and B.
Good morning, Your Honor. This time, Mr. Pastor Stanton, the right, the state name for the records. Oh, yes.
All right, and good morning. Today is the date. Whoops, that's on that one.
My bad.
And thank you for dressing appropriately for court. Today is the date scheduled for the arraignment on the misdemeanors and the formal hearing on the civil infractions. So counsel, as to the arraignment.
Plead not guilty on his behalf.
All right, the court will read the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
Just requesting discovery. I got retained on Friday and we came to court today. So I just want to get the discovery. I've already had some preliminary discussions with brother counsel, but I'd like to do my due diligence.
Of course. Ellie will tell us the date here in just a few moments.
June 15th at 10:45.
The June 15th work for you, counsel?
I have a front of the court hearing at 10:15.
Um,
And the other attorney's quite verbose, so I might be there for a while.
the other attorney's quite what?
Verbose,
Oh,
and they don't keep their mouth shut. Just,
oh, haven't heard that adjective in a while.
and you remember back to your family law days, the ones who don't stop.
I do.
On anything.
I do. Okay, so, would 8:30 work?
I mean, if I could get no disrespect, but like if it's 8:30 and we're at 8:30 and I'm out of here by 9, yeah, it works.
Yes, well, just when you check in, just so you know, I'm usually here by 8:00, 8:15, sometimes 7:30 or 7 a.m. It just depends, but I'm usually always here. We generally are waiting just until the cases are ready to be called. So if when you come in that morning, counsel, just let them know that you have to be out of here by 9 a.m. and then they'll let me know when everything's ready.
Okay.
And then as to bond.
Your Honor, he thank counsel after we're here today. He was here early for court. I would just ask for personal bond. There's no reason to run with this. And I mean, it's only going to make it worse. And like I said, he's been in contact with me over the weekend as well. Was just asking, about when to be here, and whatnot. So I have no doubt that he'll be here bright and early at 8:30.
All right, and so Mr. Hess, if you're to test right now, what's in your system?
Nothing, ma'am.
Have you ever failed to appear in court for any reason, sir?
No, ma'am.
You're not out on bond in any other jurisdiction?
No, ma'am.
All right, sir, do you work?
Yes, ma'am.
All right, where do you work?
I'm an insurance broker for North American Senior Benefits.
Do you have to leave the state for employment, sir?
Yes, ma'am. I am a district manager for Ohio, Indiana, and Michigan, but I will not be leaving Michigan.
Okay, between now and June 16th, you won't be leaving, or June 15th, you will not be leaving Michigan?
Yes, ma'am.
Okay,
Your Honor, could I just ask for that he'd be able to leave for work purposes? Because I know how this one goes is his company calls him and says he needs to go, and it's going to be a scramble drill to get a letter into you for within the 24 hours. I mean, it's clearly a possibility he might have to travel, and I just for work purposes, but it sounds like it won't be a big deal, but I've went down this road before.
okay. All right, so sir, what I'm going to do is I'm going to order a $7,500 personal bond. You're not to possess or consume any alcohol or drugs that are not prescribed. You also, sir, may leave the state for work purposes with an email sent to the court. That doesn't mean you have to wait for a response from the court. You just need to send communication to the court, something from your work, just stating that you had to leave the state for work purposes, just something that's verifying that. You don't have to wait for a response that's giving you permission, because I'm giving you that permission. You just need to submit the information to the court, so we know that's why you're leaving.
Okay, thank you.
All right, so the discovery order has been signed. And so council, just have a seat. You got a copy of your discovery order, and then so you get a copy of your probation, your bond conditions.
Okay.
Oh, thank you. Oops, you know what? I'm sorry, we have to put this, I have to add this into it too. This goes inside of it. Thank you. Okay. All right. Thank you very much. Have a good day.
You as well.
Thank you. All right. We are on the record in the matter of the city of Riverview versus Edrin Davis, 26287-21878.
Marie Connor Gun Borglum, P64889 on behalf of Mr. Davis is to my right. Or complete name of the record, sir. Edrin Ron Davis.
All right. Thank you for dressing appropriately for court. And you have a great, we're having a great day of good trusters today.
Yes.
Okay, so today is the date scheduled in this matter for the adjourned pretrial. It was originally scheduled for May 11th, but and nobody appeared, and so you had the wrong date. So here you are today. Okay, so counsel, has there been you had an opportunity to speak to the prosecuting attorney in these matters, correct?
That's correct, Judge. We did receive the discovery. We reviewed that. I believe we have a resolution.
All right, can I place that resolution on the record?
Yes, Judge. With respect to the false information to the public safety officer, that's being amended. Parking. And the operating while intoxicated, my client would be accepting offer. That would be amended to operating and visibly impaired.
All right, so please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth? Please speak up.
Yes.
Okay, thank you. Just to make sure we're getting on the recording, okay? So, sir, you did hear the plea resolution that was placed on the record, correct?
Yes, ma'am.
As to the amended charge of double parking on your 21 case, how do you plead?
Responsible, ma'am.
You've gone over, and I'm sorry, as to your amended charge of operating while visibly impaired on your 26 case, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes, ma'am.
You also understand that by entering into a plea, you'll be waiving some of those rights.
Yes, ma'am.
And you also understand sort of the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
And any immigration issues?
No.
All right. And counsel, if you can please report to your client as to the operating while visibly impaired.
Mr. Davis, on the date and time in question at the alleged location. Well, before that, did you consume some alcohol? Yes. Can you describe what you had consumed? It's like a sort of energy drink. It was like a twisted tea, And that contains alcohol? Yes. How many of those did you consume? About 2.5. And then you proceed to operate a motor vehicle after consuming that alcohol? Yes. And would it be fair to say that the consumption of that alcohol did impair your ability to operate that vehicle at that time? Yes. And would you say why it impairs your ability to operate that vehicle? To operate safely.
I can't hear you, sir.
Would it be fair to say that you were not conscious behind the wheel? Yes. And that was a serious impairment, correct? You'd agree with that? Yes. And this occurred in the city of Riverview, correct? Yes. The date and time in questioning the alleged location, correct? Yes. And nothing further, Your Honor.
That's at February 28th of 26, correct?
Yes, Your Honor.
All right. And are you stipulating to the 0.134 counsel for the level?
For the purpose of the plea, yes, Your Honor.
Yeah. All right. And well, you weren't in a Taco Bell. You were apparently at the green light in the turnaround near Taco Bell. Taco Bell always seems to be named, not always, but very frequently named in OWI cases. All right, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge, and then continue your bonding conditions on that matter. If you were to test right now, sir, what's in your system?
Nothing, ma'am, sorry.
Okay. All right, you're going to go see probation on that matter. As to your 2-1 matter, the court's going to accept your plea to the amended charge of double parking, dismiss the original charge per the plea agreement. That's $200 plus there's a warrant fee. Is there a warrant fee and clearance fee on it?
No, $50.
All right, $50 warrant fee for a total of $250 on that matter. Which you did post the bond, sir. So do you have the difference of $50 to pay today, sir?
No.
All right. Please stop at the window. Somebody will be with you shortly on that matter. You may be able to take care of that probation as well. Okay, because you have to go to probation on your other matter. And counsel, you may also coordinate your calendar for the sentencing date with
Yes,
us.
yes, yeah.
Okay. Thank you. Have a good day. Thank you. All right. Let's go on the record in the matter of this must be from last week.
Yeah, he was.
Oh, this was last week, yeah. Let's go on the record in the matter of the City of Wyandotte versus Daniel Watson, 26662.
Good morning, Your Honor. Neil DeBlanc here on behalf of Daniel Watson, who joins us over Zoom from the ruling cell. Mr. Watson, can you hear? Please state your name, sir.
You have to hit on mute. Hold on, sir. Hold on. Bobby, can you hit on mute, please?
Daniel Watson.
All right. And good morning. And counsel, ask me arraignment.
Yes, my client waives formal reading stands mute for the charges.
All right, the court will wait a formal reading. Enter a plea of not guilty for purpose of the arraignment. Scheduled this matter for pretrial.
May 27th, 25,
May 27th at what time?
8:45.
May 27th at 8:45 a.m. And counsel as to bond.
Yes, Your Honor, Mr. Watson lives in the city of Detroit, supports his wife there. Rest in the court to, he indicates he's not on probation or parole anymore. Rest in the court to set a reasonable.
Sir, where is it you work?
I'm not working right now.
Why not?
I just got let go from my job.
Okay, where were you working?
I was working at Bears Processing and Trades.
Okay, and when were you let go, sir?
Last week.
And why is that?
They're just slimming down their staff.
Okay. Are you currently on probation or parole anywhere, sir?
No.
Okay. And tell me about your matter from the 33rd District Court from September of 25. Did you resolve that or do you still have a warrant?
No, it's resolved.
Okay. When were you released from jail in your matter for 28th District Court?
Which one is that? Southgate?
Yes, sir.
I was released 2 months ago.
2 months ago. And if you were to test right now, sir, what's in your system?
No.
What's that?
No.
Okay. Sir, something tells me that your drug use is what has fueled your multiple convictions for retail fraud, attempt retail fraud, another attempt retail fraud, disorderly person, Would that be about right, sir?
Yes.
Okay. So it seems to me, sir, as though you might need some treatment. Would you agree or disagree?
Yes, ma'am.
Do you want treatment, sir?
I do. I've never had it, so I'm definitely want it.
All right, good. We're going to make sure that you're getting it then. The court's going to order a $10,000 personal bond, defendant to be tethered to treatment through the Wayne County Jail. You are not to possess or consume any alcohol or drugs unless prescribed. So, sir, what will happen is you will be processed down with the Wayne County Jail. They will find appropriate treatment for you inpatient, and you will begin your treatment process.
Thank you.
Have a good day.
Thank you.
Thank you. Let's go on the record in the matter of the City of Wyandotte Riverview versus Erica Moigno. 26460.
Good morning, Richard G. Serrano, PPO. Today I'm here with my client, Ken Runaway Horse, and the date and time set for a pre-trial. Ma'am, please state your name.
Erica Moyno.
Okay. All right. And good morning. And today is the date, and thank you for dressing appropriately for court. Today is the date scheduled for arraignment and pretrial. Counsel asked to the arraignment.
After arraignment, I'm going to interview my client. I've explained to her the nature of the charges, all maximum penalties involved. She understands those. In addition, she has signed that she understands her full advice of rights, which I've explained to her as well. This time we waive formal reading standard. You that's for plea of not guilty for arraignment purposes.
Before we waive the formal reading, enter plea of not guilty for purpose of the arraignment, and then counsel asks the pretrial.
As to pretrial, Your Honor, my client wishes to avail herself of the offer and that she will be responsible to the added charge of truancy. I'm saying what that entails. It's a fine only. And Your Honor, if that's accepted, the original charge will be dismissed. Her husband and daughter are present in court. Her daughter is the subject of the initial complaint here out of the truancy matter.
All right, ma'am, please raise your right hand. Do you solemnly swear or affirm testimony that's given this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. And you heard the allegation that was placed on the record, correct?
Yes, Your Honor.
And as to the amended charge of truancy, how do you plead? Responsible or not responsible?
Responsible.
You've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of the rights.
Yes.
And you also understand by entering into a plea, you'll be waiving some of those rights.
Correct. Yes.
You understand as well the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, I'm sorry. And so the court does find the plea is knowing and voluntary. Okay, ma'am, why is your child missed so many days of school?
She had a lot of medical issues. Well, following Christmas break, she was off for a week and a half. She had COVID and the flu together. Just a lot of I have all the notes with me, and I did provide them to the school. I think while I was gathering all the medical documentation, the assistant principal was going to try to remove the case, but I think since it was already so far in the process, is why we're here today.
Okay.
She's back in school, correct?
Yeah, she's back in school.
In person?
In person. That was the big goal of hers, my daughter, to remain in person and not to do online.
Okay, well, good. I think that online school isn't really school, actually. It's just assigning assignments. It's not teaching anything.
Mm-hmm.
Okay, so then why is your daughter here today and not at school?
Well, I kind of thought you might question that. My husband thought it'd be important for her to be here.
Okay, all right. So are there any of the days that that your daughter was absent, that just for days that she just didn't feel like going to school, or were they all medical related?
They weren't all medical related, as I explained to the attorney. That it was a hostile environment going back to school. There was a lot of rumors, to the point the school counselor contacted me to figure out what was going on with her. I was going around 6th, 7th, and 8th grade, and I got to the Riverview High School as well from siblings talking. So actually the day the officer delivered the ticket to me, she was home, and he asked why she didn't go to school that day. And I said, she's ready medically to go back. Honestly, it was bad. So she got put into inpatient mental hospitalization. For a while.
And she's doing better now?
Yes.
Very good. Very good. And so your daughter can just stay right there. But as I make this statement, there's mean people everywhere. People, whether you're in school, high school, college, in the professional work environment, whatever it may be. There are mean people everywhere. People will start rumors because they're making comments about something they know they don't have any factual basis on at all, whether it's just a perception or just an assumption, whatever it is. And then one thing leads to another and it just takes off. And then people will focus on that because then they don't have to worry or focus on something in their own life that they're not happy with. Unfortunately, you happen to be the target of that this time. So hopefully that doesn't move forward, or that doesn't happen again moving forward. But I also hope that now you've been able to equip yourself with some coping mechanisms so that when that occurs in the future, because it's not an if, it's a when, it just depends on where you're at, as to what level that will be, whether it's in school or work or what have you, so that you can continue to stand up for yourself and just let them know that it doesn't bother you. Okay? All right. And so the court's going to order a $100 fine. Do you have that to pay today?
Yes.
Okay. All right. Stop at the window and somebody will be with you shortly.
Okay. Thank you so much.
Welcome. All right. Good luck to you.
All right. Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. We're on the record, the matter of the city of Riverview versus Niall Williams, 26458 A and B.
Your Honor, good morning. This is Chief Scott, Chief in PA28, appearing on behalf of my client. This is my right. Ma'am, could you please state the name for the record?
Niall Williams. All right. Thank you. And today is the date scheduled in this matter for the arraignment and pretrial. And counsel as to the arraignment.
As to arraignment, Your Honor, I have had an opportunity to interview my client and speak to her regarding the nature of the charges, all maximum penalties involved, be it from this court or any administrative agency, and understands them. Thereby today, we waive final reading, stand mute, and we have a resolution as to the pretrial.
All right. The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
As to pretrial, Your Honor, my client availed herself of the offer made by the prosecutor. She will plead guilty to the amended charge of allowing an unlicensed driver to operate a motor vehicle to it herself, and also the amended charge of no proof of insurance. She will admit responsibility to that. If those two pleas are accepted, the charge will be split down the prosecutor will give.
All right. Thank you. And so, ma'am, I'm going to have you please raise your right hand. Your right hand. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of allowing a licensed driver to drive, how do you plead?
Yes.
Don't say guilty.
As to the amended charge of allowing an unlicensed driver to drive, how do you plead? Guilty or not guilty?
No, I'm the unlicensed driver.
That's correct. So are you pleading guilty as we discussed?
Oh, yes. I'm sorry.
Okay, that's right. So as to the amended charge of allowing an unlicensed driver to drive, how do you plead?
Yes.
Yep, say guilty.
I need either guilty or not guilty, not yes or no. I need guilty or not guilty.
Guilty.
Okay.
I'm sorry, this is my first time in the courtroom, so I
no, that's okay. That's all right. And you have gone over your advice of rights with your attorney, is that correct?
Yes.
And you understand all of those rights.
Yes,
You also understand by entering into a plea that you will be waiving some of those rights.
yes,
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yeah.
Yes?
yes,
Okay. Knowing all of that, do you want to continue with your plea?
yes,
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
no,
Any immigration issues?
Are you a U.S. citizen, ma'am?
no.
You're not a U.S. citizen?
Oh, I'm sorry. Yes, I thought you said something else. Yes, I am U.S. citizen.
Okay, so do you have any immigration issues?
No.
Okay. All right, counsel, please board hear your point.
Ms. Williams, apparently, on March 28, 2026, were you operating a motor vehicle in the city of Riverview?
Yes,
And at that time, you have contact with the police. Is that correct?
yes,
All right. And first of all, upon the officer asking you to produce a valid proof of insurance, were you able to on that occasion?
no,
All right. And also, as to your operator's license, were you able to produce a valid Michigan operator's license to the officer?
no,
That's because you allowed yourself to drive while having a suspended license. Is that correct?
yes,
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charges. And I'm sorry, as to the amended charge of no proof of insurance, how do you plead? Responsible or not responsible?
yes,
Responsible. Responsible or not responsible?
yeah. Responsible, I'm sorry.
All right. And so the court does find the plea is knowing, voluntary, and factually accurate. Will accept your plea to the amended charges and dismiss the original charges per the plea agreement. And counsel, are you asking for immediate sentencing?
If the court pleases, yes, Your Honor. My client is married. She supports 2 children. Your Honor, she currently works for Symphony Applewood as a certified nursing assistant. And Your Honor, she's not on probation or parole. As you heard her say, this is her first time in court. Your Honor, I think she's learned an expensive lesson that she keeps driving is going to keep getting suspensions. In fact, she does have 2 matters pending. One in Taylor for DWLS, driver license suspended. Also one in Lincoln Park for having no insurance. So it sounds very similar. She's taking care of that and she will avoid getting those charges in the future. Is that pretty accurate, ma'am?
Yes,
She'll need time to pay, Your Honor. She does have $100 you can take in,
yes,
paid towards fines and costs. With that, we leave in the court's discretion.
Okay, so ma'am, what is the status of your driver's license? Do you have a driver's license?
yes. I'm currently going through my case with Taylor Police Department. My next birthday is June 8th. Lincoln Park, I only owe them a fine for driving with no insurance.
Okay, I understand that with your pending cases. I'm asking about your driver's license. Do you have a driver's license?
No, I haven't. I had to make my next appointment to pay the fine with Lincoln Park. That's what's stopping me from receiving a driver's license.
Your Honor, a better question, if I may. Have you ever had a Michigan operator's license?
No.
There you go.
Right, so I said, do you have a driver's license?
Yeah, so the answer is no.
Okay.
Never applied.
Okay. All right. Okay, how'd you get here today, ma'am?
I'm sorry?
How did you get here today to court?
After I got here, I got dropped off.
Who dropped you off?
A friend.
You sure you didn't drive?
No.
Ma'am, it's very likely that if you drove here, you're going to get stopped and arrested in the parking lot. So tell the judge the truth. Did you drive or did you not drive today?
Did you drive here today?
Yes, I did.
That's what I thought. So, ma'am, I'm going to presume that you want to have a valid license at some point, correct?
Yes.
Okay. Then stop driving. Stop driving. How old are you?
Your age, man.
1998.
26.
How old are you, ma'am?
Yes.
How old are you?
I'm 27.
Okay, 27. Okay. So, ma'am, I'm not sure why in the last, even if you waited till you were 18, why in the last 9 years you haven't gone to obtain your driver's license? Because it seems as though you want to drive since you continue to drive without a valid license. So, in the state of Michigan, it's a privilege to operate a motor vehicle. You don't have that privilege right now because you do not have a valid license. So stop driving. Okay. The friend in air quotes that dropped you off today can be the friend that comes to pick you up because you cannot operate your motor vehicle. Is that a problem?
Yes.
It's a problem?
What? I'm not understanding what's the problem.
Well, I saw you rolling your eyes, so I wasn't sure if that was a problem to have somebody else come pick you up.
See me roll.
And the court wants to know how you're going to get home because you're not driving the car or the vehicle unless you want to get arrested. So tell the court how you expect to get back.
I will find a way home.
Okay. Make sure you're not driving because they will be watching.
Okay.
The court's going to order a $200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, a total of $525, and then $175 with no proof of insurance. So that's a total of $700. You said you can pay $100 per month beginning today? Is that
Yes.
accurate? All right. So, ma'am, I'm going to have you stop at the window. And you can make your first payment. You can get information about paying online, okay?
Yes.
Thank you, Your Honor.
Ma'am, a word to the wise, stop driving because you're going to just be giving courts your money and then you're going to prolong how far it will be before you can get your license, okay? I know it's difficult. I know it's not easy, but this isn't the way to go about getting your license, okay? Stop at the window. Somebody will be with you shortly. Have a good day.
Thank you, Your Honor.
Okay, and then we are on the record in the matter of the city of Riverview versus Kyle Brown, 26456.
Right here. Then please state your name.
Kyle Brown.
Thank you.
Hello. All right. Good morning. And today is the date scheduled for the arraignment and pretrial in counsel as to the arraignment.
Yes, my client waived formal reading, stands mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial.
As the pretrial, Your Honor, we're asking for a German purposes of discovery as well as reaching out to the alleged victim prosecute cause.
Okay, hold on 1 second here. Looking for the notice of prosecuting officials in here. Much. I don't believe is in here, so give me just 1 moment. All right, and all right, and so then we waived the formal reading, correct, counsel? All right, and then you're asking for an adjournment for discovery purposes, correct?
Yeah.
And then Ally?
June 15th.
I'm sorry, we said June 15th?
Yes.
Okay, thank you. The court assigned the discovery order as well. And counsel as to bond.
As the bond, my client advises he's not on probation and parole. He's never failed in the and a court hearing. He supports 3 kids. He's gainfully employed with a company called Special Vending Services. If I have that correctly, VSS. Oh, I'm sorry.
SBS.
SVS. That's better. And so we asked for the personal knowledge.
Sir, how do you know Noel?
Okay, could you repeat that, please?
Noel.
That's a much better way to ask me to repeat myself rather than,
Repeat that question, please.
How do you know Noel?
Mutual, like through mutual people. She knows people that.
There's no reason for them to be in contact with each other.
Okay, so she's not the mother of any of your 3 children?
Oh, absolutely not.
Okay. And you don't have any reason to. And so the 2 of you don't have any reason to have any contact, is that correct?
Yes, ma'am.
And you're self-employed, sir?
No, I'm not self-employed. I'm employed with a company called Specialized Vending Services in Livonia, Michigan.
Do you service anything in Monroe?
No.
Who's Andrew Henderson? Is that a roommate? No. Just somebody that lives in your building, apparently.
Yeah, I live alone. Just my children.
Okay. And you're not on probation or parole anywhere, sir?
No, ma'am.
All right. So I'm going to indicate no contact with Andrew Henderson.
I don't know who that is.
Okay, well, apparently he lives in an apartment in your building, but what I'm going to indicate as well, is regarding the incident for the case. All right, because I don't want it to seem as though I'm setting you up for violations, sir, because you may encounter each other in the doorway or something of that nature. Since you don't know who he is, it may not be difficult to not have contact with them, but in the event you're both walking at the same time with groceries or something, that would not be a violation.
Okay.
Are you out on bond in any other jurisdiction, sir?
No.
And you're not on probation or parole anywhere?
No.
Have you ever failed to appear in court for any reason?
Don't have.
All right, the court's going to order a $7,500 personal bond. You're not to have any contact with Ms. Boyd. That's phone contact, text message, email, social media, third party, anything of the like. You're also, as I've already indicated, not to have any contact with Mr. Henderson. You also are not to return to Ms. or go to Ms. Boyd's place of, in her home or place of employment. You are not to have access or possession of any firearms or ammunition or weapons. Do you have any of those, sir?
No.
Okay, I need to make sure these are not getting. The individual in your Westland case was not Ms. Boyd, is that correct?
Correct.
All right. And the court's going to also order GPS tethered through the Wayne County Jail, no house arrest. To ensure the safety of the victim in this matter. And so, sir, you're going to, Kelsey, you'll get a copy of your discovery order. Sir, you also get a copy of your bond conditions, yes.
I was gonna say, with respect to the GPS tether, well, we consider that he has no reason that this person, this one doesn't live there, he's got no relationship.
Well,
Children.
and counsel, I can appreciate that. However, given the nature, your client's criminal history, and some of the assaultive convictions your client has, the court just wants to have that extra layer of protection for the named victim in this matter. We can certainly revisit it June 15th. But for now, that's what this court's going to put forward. So you get a copy of your bond conditions, sir, from probation, or from either from here. In any event, you can't leave without going to probation to get your information. Okay.
I'm sorry, one more point. Do you want to answer?
Yes, please.
Mr. Brown has indicated it's made it difficult with respect to coming back in person, is asking if the court would grant permission to appear at the next hearing via Zoom.
Why are you having difficulty getting here in person, sir?
Because I have my work schedule, it's a conflict with my work schedule. Like I said, I take care of my 3 children. My youngest daughter is autistic, so I don't really want to miss out on the money. Or if I could, if you don't know, hold Zoom, you give me like a 1 o'clock court appearance. I can be here because I work from 3 a.m. to around 11:30 in the morning.
Okay. Well, sir, unfortunately, I can't do a 1 o'clock PM. But if you just, we can set it for 11:15 AM. And that way you just have to leave work a short time early to be here in person.
I won't be able to leave a short time early because I fill vending machines and I work out there in the city of Warren, Sterling Heights, East Point. So I have to go to my shop, fill my truck up, take my truck out, and then I'll have to go back to my shop, get my car, and come up here. It just would set myself up for failure.
Well, sir, my question is this. Okay, so what'd you do for today?
I called off, but what I'm saying is to keep missing days. If I can't, I understand, but to keep missing days is financially is going.
No, I can appreciate that. But so you can't work only until like 9. You're not allowed to work only half a day or half a shift.
No, they're just going to tell me not to come in on point, and then I just lose that day.
Okay.
Like today, I lost 2 days of wages. I don't get time for a PTO until August.
Okay. And so I can appreciate that, but it's a bit more difficult when individuals are on Zoom. For right now, I'm going to say appear in person. If Mr. DeBlois, you and Mr. Johnson have had conversations between now and then, and there's a resolution that's already worked out, you let the court, you communicate with the court about a week ahead of time, then we could possibly amend it to be Zoom.
I will be in touch with Mr. Johnson about that.
Okay. And then just when you're making that request, just say, hey, remember, this is the individual with the vending machines. I asked if he could appear using.
Yes, I understand.
And I should remember that. I hope.
That's yeah. That's it's an illustration that you can grab onto.
Correct. Correct. All right.
I estimate this lesson.
Okay.
About the tether and everything. One, how do I go about getting that? And like he stated, I would never run into this girl again. You know, I understand the past, what I have in my past, everything. Those were years ago and everything. Like I say, as summer's coming up, pool's just about to open. You know what I'm saying? I understand you have a job to do with everything, but I'm not looking to create no trouble or run from this situation. I'm looking to do.
Okay. And I can appreciate that, sir. And again, I only have this small little snapshot of what I have right here. And so I have to make my best judgment call as to the bond conditions. So today, that's the judgment call I've made. Probation will give you the information about getting the tether on. Again, we can revisit that on June 15th, likely having that removed. Okay?
All right.
All right. Thank you.
Thank you.
All right. Thank you.
Keith, Mr. George has also joined us, and that's very helpful.
Is he Mr. Coon's attorney?
He is in the
PV case, Your Honor.
on the probation violation.
Which that's, I think, that's what this is.
Well, yes.
Mr. George, are you able to handle this brief probation violation arraignment with your client?
Yes. Well, Keith, he's also got another drunk driving charge where he's represented by Paul Gibson. And there's not a bench warrant in that case. I think his trial was set for one of the days the power went out. And in March, and I don't know what happened to it, frankly. I think it got set aside, and my secretary brought it to me earlier in the week and said, hey, we need to do something with this case. So there was a plea offer in the second case. The second case is the one where he was allegedly doing burnouts in the parking lot of the old Three Rivers Hospital at 2 o'clock in the morning, and he was a 1-7 or something. He also has some significant mental health issues. So we'll see how he's doing here today.
Do you need me if you have Mr. George?
I'm not sure. I guess not. Mr. George doesn't represent him on the other case. What I originally thought I would do, and I still may do, is just tell him what it is, set the matter for a probation violation hearing. Daniel, his probation agent, isn't here. He's on vacation this week. He'll be back next week. And I think Mr. George can certainly deal with that.
Sure. All right. If you're okay with that, Tim, I'm going to duck out.
That's fine with me, Keith.
I appreciate it. Tim, I'll have to chat with you about, I got to wait till tomorrow morning. I'm working on something else I got to chat with you about. So,
sure.
Thanks. Bye.
They're apparently in the attic up above us. Let's hope they don't fall through. Good afternoon, Mr. Kuhn. Can you hear me?
Yeah.
All right, this is Judge Middleton. I'm here at the courthouse. Also here with me is your lawyer, Tim George. You have two lawyers. The first case, you were charged in 2024 with operating while intoxicated. That was in file 241568 SD. You were on probation in that case, and Daniel Frazine was your probation officer. While you were on probation, you again got arrested for operating while intoxicated on June 17th of last year at Three Rivers Historic Hospital location. That matter was set for trial on March 18th of this year, and I believe the power went out that day, and we weren't here. We were here, but we weren't operating in court. Your probation officer, Daniel, filed a probation violation petition alleging that you have violated your probation by doing several things. He alleges that you violated your probation by getting arrested again, failing to pay fines and costs, failing to abstain from the use of drugs and alcohol or test as directed, and failed to participate in treatment. That was set for a probation violation hearing, and you didn't show up. So we issued a bench warrant for your arrest, and you've been kind of off the radar for several months. Your parents, I think, live on Hutchinson Road. The last I knew, you were living in your vehicle with your dog, and I wasn't sure where you were. You also have a new charge where they charge you with retail fraud, but they charge that as a civil infraction. We won't deal with that today. We need to get your probation violation matter back on track. You have two lawyers. You have Mr. George on the probation violation, and you have Mr. Gibson on the drunk driving case from last June. The case is so old because you keep slipping through the cracks. We had it set for trial and the power went out and we weren't able to do anything, and then it slipped through the cracks on us. So let me ask you a couple of questions. How did you get arrested last night? Ashton, how did you get arrested last night?
Just sitting there at the bench. That's not the library.
Where
Where were you when they picked you up?
Sitting at the library.
In Three Rivers?
Yeah. Just sitting there.
In your vehicle or just by yourself?
Nope. With my dog, crackhead stole my Suburban.
All right,
Actually,
so
someone
you still have your Suburban?
Nope.
Correct?
Someone stole it. Nope. I have no clue someone stole it.
All right, so your car was stolen. Do you still have your dog?
Yep, she's actually right here at the she left from DP last night and then they put her up here close to me.
All right, so you got arrested with your dog yesterday evening at the Three Rivers Court building?
Yeah, just nothing illegal activity, no illegal activity whatsoever.
Well, the problem is you had open warrant for your arrest because you hadn't shown up for your court hearing. So that's why they picked you up. All right. Mr. George is gonna need to come out and see you at the jail. I'm gonna show that you plead not guilty to the probation violation. Several allegations that they could do without trying the other case, failing to test, failing to go to treatment, failing to report. And that could be the basis. So I'll show you plead not guilty. We're gonna set a probation violation hearing next week. Looks like I may have several open days. Mr. George, what's your prognosis for the Michael Jones case?
It's still in progress, Your Honor.
Does it look like it could be settled?
Possibly, but I don't have confirmation on that.
All right. Anyway, I want to hold on to you. Where have you been staying?
In the streets.
All right, and I don't like that. That's not good for you. And at least now you're in a place where you get three. Now your shirt looks clean and your hair looks clean. Have you been showering somewhere, or is your mom still doing your laundry, that sort of thing, or you're just sleeping under a bridge?
No, me and my dog do quite fine. I actually love that. I like being outside and freedom because it is safer and more pleasing, even though I don't have money and no circumstances of financial means of somebody to take care of me. That's fine, I'm a grown man. My dog Raven and me, we do very well, even though it gets hard out there, but it's better being out there than in here just because that's freedom is freedom. Ride it down for freedom.
All right, freedom is freedom, but it doesn't go very far when you don't have any money. All right, I'm gonna cancel your bond. And we'll set a hearing for one day next week. We've also got to reschedule your other drunk driving case. I'm hopeful maybe that while you're in custody, we can resolve the probation violation and the pending case from the hospital last June. But I keep losing you because you're homeless. You don't get your notices, you don't show up when you're supposed to, and then it takes a couple months to pick you up again. So I'm just gonna hold on to you. I want to make sure you're safe, fed, secure, and available to both of you and see if we can resolve it.
I just forgive me, Your Honor, but that is no, forgive me. That's not a rush of disorientation. That's not acceptable. That is taking away somebody's freedom of rights to be out here and freedom just because.
Yes, I'm taking away your freedom until we have a further hearing in this matter. So I'll see you next week and we'll try to schedule a date. I don't know how he's doing, but Dan will be back Tuesday. I don't know what he's got going on. I think his parents might still be helping him a little bit. But he's not in a good place.
But thank you for being here.
Yes, sir.
For that. Richard Truckee. Mr. Truckee's been here every day this week trying to deal with this. You got a ticket. I looked this up after I saw you in the hall earlier this week. I'll just tell you what I know about it. It's alleged that on December 1st of 2025, you got a formal charge of allowing an animal to run at large. Your horse did permit or enable his horse to run at large. That is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. I was charged by Chief Assistant Prosecutor Joshua Robert. According to the affidavit of probable cause, they got a call from animal control. Your horse got loose on September 12th, and the mail carrier put him back in. They got loose on September 17th, and the troopers went out there, and then they were going to make a plan for you to have a better way to keep your horse contained. On April 14th, your horse got loose again at 4 o'clock in the morning. And on December 1st, your horse got loose again. And they got tired of chasing your horse and they gave you a ticket. So that's how all this went down. So they tried to call you in December and tell you they were going to give you a ticket, but they couldn't get a hold of you. So prosecutor authorized a formal complaint. They tried between December 1st and December 4th to call you. And it says, as of 12/12, all efforts to make contact with Mr. Truckee have been exhausted. So they turned it into the prosecutor and they issued a warrant. And then apparently you just got arrested earlier this week. All right. So how do you plead to this charge of having your horse at large?
Can I ask you a question?
Yes, sir.
Okay. So, I have my own attorney, but he also said to come in and talk to the public attorney, and something like this on this horse. I'm just being strictly honest. I don't have a ticket in hand. I never signed a ticket. Okay, and not only that,
They didn't give you a ticket. They issued a
I
warrant.
did call Centerville. I know, but I did call Centerville to get a hold of the animal control lady, and she never called me back. And I did proceed, I'm talking with her, and she did bring a state trooper out, and she had a document that she filled out a bunch of paperwork, but she never issued me a ticket, and I never received a ticket.
Why don't I take a minute and let him to talk?
Yeah. They didn't give you a ticket.
But I don't have one, and I never
They
signed one.
charged you on a formal complaint.
I know, that's kind of crazy too. That's why I was wondering why.
Well,
I would have paid a ticket. If I would have got a ticket, I would have paid the ticket.
Well, this isn't a ticket.
Okay, I understand.
It's a misdemeanor.
Okay.
So you can go to jail for 90 days for this. A ticket is like speeding. So I'm not putting you in jail for 90 days, but
Yeah, I
it's a
understand.
misdemeanor.
But it's kind of
And this happens.
Okay.
I've been here 47 years. I've probably seen 47 of these cases. Sometimes they're cows and the police get tired of wrangling cows in the middle of the night. Sometimes they're pigs.
And there was, can I just one quick comment? There was 3 horses. Okay. And
all right, don't say any more about it.
Okay.
The public defender is going to talk to the prosecutor.
All right.
One February night in 1996 was actually the night Carol Knepp was murdered. A cow fell off a transport truck in Montville Township, and it was a steer. And so there's a steer rambling around about 10 o'clock at night in Montville, and somebody shot it in the head, but all it did was make it mad. And the state police are trying to wrangle this steer. And they get a call that there was a car that had run up against the house. And so it ended up being a murder situation. So I don't know. They left the steer. I don't know whatever happened to it. I don't know if anybody ever caught up with it or, I don't know why that's popped in my head, about animals at large. Anyway, Mr. Stickley will confer with the prosecutor, Mr. Truckee, and we'll see what the deal is. So you have a seat for a minute.
Sure.
All right, we're not going very fast.
And do I get the right to talk about?
Yeah.
I'll check.
Good morning, Miss Richmond. I'll be with you in just a minute.
My name is not Richmond. My name is Wheeler.
Oh, Christina Wheeler. All right, got you.
I need to get my glasses. I cannot see anything. I didn't know I was coming in here.
All right, well, I don't look that good, even if you had glasses on. So maybe we'll just try to get through it, yes?
Okay.
She's released. All right, Vivian, you're good to go. Thank you.
What do you mean I'm good to go?
Thank you, Your Honor. Have a good day.
Let's see.
All right. Miss Wheeler. I'm Judge Middleton. With me is the Chief Public Defender, Mr. Keith Stickley.
Okay.
You had a charge of illegal entry. You got charged in this file 26466 SM with illegal entry. You got arrested in April. You posted a bond in May, and then you didn't show up for your pretrial.
I don't know how I get here. I had a job I lost and no transportation.
All right, so we issued
I'm
Judge
not
Patterson.
from here. I don't know how to get over here.
All right, they issued a bench warrant for your arrest. So let's take a look at your actual circumstance here. All right, the original complaint alleges that you went into a building at 304 East Chicago Road without permission. It was a homeless situation. And they
Yes,
charged
that's correct.
and the person that owned the house wanted to get everybody out of there, and you were in somebody else's house without permission. So that's the illegal entry. So you got arrested, you posted a bond, you got arrested again. You got arrested on the 27th. You posted bond on the 4th. So that's 3-7. You've been in jail for 8 days altogether. So if you plead guilty to this charge of illegal entry, I will represent to you that I will give you 8 days jail credit, 8 days, and let you out of the jail if there's nothing else holding on to you.
The only other charge I have is the possession of methamphetamines they had. It was an empty baggie in my bed.
The magistrate will see you on that later.
Hang on.
All right. This is just this illegal entry case from last January where you were in.
Okay, I'll take care of it now.
All right. Are you willing to admit that you were in there without permission?
Yes.
Morning, Mr. Gabriel.
Excuse me.
Anybody threaten you to get you to do that?
No, I was in there because I was homeless and trying to stay warm. The house had electricity.
Yes, that's what I understand. Do you understand that by pleading to this, you'll be giving up your right to have a trial in front of a judge or a jury? There will be no trial. Do you understand that?
Yeah. Yes, I understand.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, we could appoint one for you at county expense. You would have a right to testify in your own behalf. And if you did not wish to testify, the judge or jury could not hold your silence against you. You could have any of the witnesses against you subpoenaed, and you are, have a right to be presumed innocent. Other than what I told you, did anybody promise you anything to get you to plead to this?
No.
All right, you already told me you were in there without permission. You got 8 days jail credit. Mr. Gabriel's helping us too, which I appreciate.
I been lost, Your Honor, I lost a whole entire job over the situation.
Say that again?
I lost a whole entire job over this situation, and a job and a place to live when after I got caught on this illegal entry, I had all of that. And because the lady wouldn't release me on my own recognizance, I lost that job and that place to live again. So now I'm currently unemployed and homeless once again.
Well, they did let you out April 2nd. You got arrested again.
Now. It took my family 8 days to get that money.
Yes. Then you didn't show up for court again. So Judge
Because I don't
Patterson
have to be here. I'm not from here. I don't have no transportation. I tried to tell them that. They don't listen. I'm not from this city. I'm not from this state.
Well, maybe you ought to go back to where you're from. That things might go better for you. I'm going to give you.
My daughter lives here, Your Honor.
I'm going to give you 8 days jail credit, 8 days as I represented. The minimum fine is $125, and you have $50 of bond, so you owe $75 for 1 day. Apparently, you got a meth charge that I don't know much about. The magistrate's going to see you later. You got the meth twitch and the itch.
No, I don't. They're from bed bugs.
Oh, well, all right.
Fentanyl is from bed bugs.
All right. Well, the magistrate will see you in a little bit, probably early this afternoon. All right, but this illegal entry case is resolved. You're good to go. Good morning.
So,
This is Judge Middleton. I'm here at the court with Mr. Stickley, the Chief Public Defender. You got picked up last night on a bench warrant. This case is fairly old. It's 2540 SD. Started as a charge of operating while intoxicated. It's full of you failing to appear when you were supposed to. The matter got reduced to impaired driving with your lawyer, Mr. John Bush. You entered a plea last November to impaired driving, and the matter was set for sentencing December 1st. You failed to appear for sentencing on December 1st, and we did a show cause, and you didn't show up for that. Our last customer is Mr. Klein. Anyway, how did you get picked up last night?
I was arrested in Kalamazoo and the charges were denied. Got attacked by a dog. I was in the middle of moving. Kalamazoo and then brought me out to St. Joseph.
What day did you get arrested in Kalamazoo?
It was Tuesday, like mid-afternoon. And I'm sorry, Your Honor, about not showing. I don't have a car right now. And I haven't had any transportation anywhere.
All right. Now you say you got attacked by a dog?
Yeah.
What kind of dog?
It was an Australian Shepherd. They took me to the hospital first to get it cleaned and put me on antibiotic.
Well, Australian Shepherds, they're smart. They usually don't attack. All right. So do you have any charges in Kalamazoo?
No. No, Your Honor. I had a really, really tough boredom since
So they found this open warrant and they brought you down here on the warrant.
Yes. Yeah. I don't know how I'm gonna get home.
I'll make arrangements for you to get home at some point, but you aren't going anywhere. You continually don't show up for court. You were set for sentencing in January. It's now late May. We're here all day, every day. You have a lawyer. You never called your lawyer. You never called the court. You just didn't show up.
No, Your Honor, I did talk to. I called him the day the car broke down. I was trying to make it.
Well, we haven't heard from you since November. The sentence was January 1st. I did a show cause, so we waited a little while. The bench warrant didn't enter until later. Anyway, we're gonna set the matter for sentencing. Your bond's canceled. We need to get Mr. Bush available. I can probably do it Monday. I'll make sure you get a ride back to Kalamazoo. Mr. Truck, you need to take your hat off.
Oh, I'm sorry. I was with him.
Mr. Gabriel, thank you for your help on this case. Just have a seat for now. Gary, we're in uncertain land. I talked to Tim yesterday on Mr. Jones, and so we'll see. I hate to bring all those jurors in. I hate to have all the jury instructions and your subpoenas and witnesses. And so let's hope we hear from Mr. George today. Would be surprised if well, I know he's been working on it. He has a view of it, and his client has another view of it. Yes, well, that's the fact that you're ready and prepared to go may induce the matter to be resolved. But I don't want to go to a bunch of unnecessary work for you and for them if we don't have to, so.
Can we, Mr. Truck, get out of here and get him come back when I get your what's going on? I have nothing.
All right, I'll take care of this lady and I'll let Mr. Truckee go. We'll set a pretrial. All right, thanks for working on it. All right, anyway, let me see when Mr. Bush is. Maybe he's here Monday.
Are you saying I'm gonna have to?
We aren't here Monday. Just a minute. Go ahead. What did you want to say?
Will I at least be able to go home until this sentence?
No. You failed to appear. This is a 2025 case. Let me see how many times you didn't show up for your original arraignment in January of 2025. You already got picked up on a bench warrant then. You called in April of 25 and we tried to get you in here. Was scheduled arraignment for June of 2025 and you didn't show up on June 6th of 2025. So finally you got reset. You came in here on June 10th and pled not guilty. And you failed. So, because you got arrested in June of 2025. Then you had some issues in Kalamazoo. We set up final pretrial in November. You failed to appear for your sentencing in February and never called since. So I believe you failed to appear on 4 previous occasions, including your sentence. You have pled guilty, so you're not presumed to be innocent. I'm reluctant to let you out for fear that you won't show up again. I'm going to hold on to you until we can get the matter set with your lawyer. So you're going to be here for a few days. I hope to do this early next week. But you're good to go. Abby? Yeah. All right. Mr. Truckee? They're trying to figure out the horse caper. Mr. Richard Lee Truckee has been here multiple times. Did you resolve all those? You just sent them out for the civil infraction?
I resolved most of them, so that's for attorneys.
And then you put it on the form? All right, thanks. I do appreciate your help. We had a lot going on. We also had 10 pretrials. Do you know, are all those done too, or there's still?
Gary helped me with some of them.
All right, thanks a lot. I would like to ask some questions, like where are these horses now and
Sure,
that sort of
you're
thing,
more than
but
welcome.
you don't have a lawyer with you. So Mr. Gabriel was willing to meet with you. He's the chief assistant. Unable to resolve. Asked to set a pretrial. So I'm gonna reset this out for a couple weeks on a Thursday. Thursdays always seem to be busy. June 11 at 8:30. Let me give you a notice. Further explain this to the prosecutor. Have you got jobs going on right now?
Pardon me?
Have you got jobs going on?
Yeah, well, today I don't because.
Well, it's probably, spring is here, people got
Oh, yeah,
jobs.
I'm going strong.
All right, well, you're gonna have to take time off
Or
on
should I just say
Thursday.
I'm completely broke? What should I? I'm not.
All right, well, you need to get back to work.
Yeah, I know, yeah.
All right, we'll try this, a pretrial. And
Okay.
Thursday, June 11th. You come back,
Is this
Mr. Gabriel.
just something to come back to?
Yes.
I'm.
Prosecutor, Mr. Gabriel will meet with you.
Now, can I talk with him just a second?
Yes, he's not here. He's back,
No, I mean, the
going back
public
to
defender,
work.
can I talk with him?
Yeah,
just a
I
second?
can talk to you, but I have a circuit court case. I got.
Okay, that's fine.
So give me a few minutes here.
All right, Mr. Stickley, you're good to go. I'm sorry, you're
No, you're
2
good.
minutes late.
Circuit Court for the County of Kent is now in session. Honorable J. Joseph Rossi presiding. We are here in the matter of Esperanza Santiago versus Kimberly Baker, case number 26-30606-PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court today on Miss Esperanza's appeal of my denial of her request for a PPO in this case. And Miss Santiago, you're present, so I'm going to swear you in and have you state and spell your name and then ask you a few questions and I can decide your appeal. So if you would raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Okay, thank you. And your request here, as I'm reviewing it, was based on, my understanding is in the past, it sounds like the respondent here, who is Miss Baker, had a PPO against you. She during the course of that PPO, you describe it as violated it. Of course, if it's her PPO, then technically she can't violate it herself, but she, implied that, it wasn't a great PPO by coming to your house and doing some damage. But how long ago was those prior incidents?
That was probably about 3 to 4 years ago, but recently it has come to light when that PPO dropped. Me and Kimberly decided that she has kids with both of my kids' dads, allegedly now. And we decided, since our kids are related, we'll put everything behind us, let them have a relationship. And in that time, Kimberly confided into me some stuff about one of her childs that's not related to my child. So her child doesn't have the father. So she confided in me about some personal things, and he is now being investigated and incarcerated over it. And when things first started coming to light, my car was shot at, and Kimberly had called me and she asked me, how's my car running? And then that's when
our son's dad was picked up for a weapons charge, and now he's being looked into for the other stuff.
Sure. Well, but how do you know it wasn't the son's dad and not her? I mean, granted, she might have known about it and everything else, but if she wasn't the one that damaged the car, how can I use that as a basis for a PPO against her unless she told him to do it?
And that's exactly what it is. They're telling each other, they live with each other, they're still together even while this investigation is going on. And even the detective had told me, I'm not going to tell you that she had no involvement in it, but she wasn't the shooter.
Yeah, well, and that's what and I mean it gets a little tricky in a case
And
like
once he
that.
did get arrested on April 9th, I
On
started getting a
the
lot
gunfire or
of
the other stuff.
the weapons charge.
Okay.
He was picked up that day for it. And that day, I started getting a lot of text messages, a lot of private calls. Kimberly's sitting there and she's like on the other end talking about how I'm miserable and she can't believe I would get him arrested. And now what is she going to do? And I'm just like, that's not my problem. Like, you guys really just came and shot up my car. And I hung up on her. I did report it to the police because she called like 15 times. She texted me off of a whole bunch of numbers. That's when they told me to screen calls in my iPhone and do unknown callers. And ever since, like, it's been just blocked voicemails and blocked voicemails.
Okay, so I mean you think she has been continuing to call you since that time?
Yes.
Okay. And have they done anything? I mean, since the shooting up of the car, has there been any other communication of a threat to you?
Since the shooting, he just got arraigned on the new charges on the 19th or the 20th. And the 19th is when, yes, the 20th he got arraigned on them. The 19th is when they put like 5 more charges against him to hold him in, because the 20th he was supposed to get out. So the 19th is when they found out they weren't going to be able to get him out on the 20th. And I started getting a lot of calls.
Then you didn't respond to him or answer him, so you don't know what was said.
Right. But they
and-
were off of a whole bunch of random text now numbers.
Okay, and you've had them blocked, and based on your past um, uh, experience, you believe these were coming from her.
I know they were coming from her.
Okay, well, that clarifies the situation for me. I when I looked at it, and I thought, well, there's the criminal situation involving the shooting of your vehicle, and that could have just as well been him. And thus, why do I give a PPO against her? And the answer is, well, whatever she knows about the situation, she's linking you to it, and she's choosing to electronically at least harass you with. And when you say a lot of calls, how many would you just guess at?
Since the 19th, I had about 6 calls.
Okay, well then what I will do is I will reverse my denial. I'll grant it. The basis for the grant is going to be unwanted electronic communication by her. And did you ask for all categories of protection, including the firearm protection?
Yes.
And that seems reasonable given a firearm was involved in this thing that you suspect she's connected to, but that just as well could have been.
I also have pictures of her daughter that is involved in the allegations with my son's dad holding a gun.
That's not good, but I don't think the daughter's probably going to be a threat to you. But I get what you're saying is there might be a little bit of a
there's easy access to weapons
easy access
around.
to firearms. That's probably not proper. So I think that's reasonable. I'll reverse myself. I'll grant the protective order effective today. Send you a copy of it. You can serve it on her, and she should stop. The calls and stuff to you. I think that's reasonable. I'm grateful you came in and explained the situation.
Thank you.
All right. Thank you, ma'am. And I'll try to get that signed and out today. Could be as late as Monday. I'm running at about 100 documents behind on signatures right now. So I'm hopeful I can well, and Monday's the holiday, so I guess it would push it to Tuesday. Hopefully I'll get all that stuff done this
Understood.
afternoon, but right, I don't want to make any promises I can't keep. So
Right. Understood. Thank you.
Very good. Thank you, ma'am. Pleasure to meet you.
Bye.
We are here in the matter of Caitlin Gardner versus Chastity Hunter McKnight, case number 26-30197-PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court on Ms. Hunter McKnight's motion to terminate a personal protective order that was entered against her. We do have all parties present, it appears, by Zoom video this afternoon. So as an initial matter, since it's your motion to terminate, I did receive the written motion to terminate the PPO. So I'll start with you, Ms. Hunter McKnight. If you would raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Sure do.
Okay, very good. And would you state and spell your name for the record, please?
Chastity, Chasity, Hunter, Hunter, last name McKnight, MIKNIGHT.
Very good. And you prefer me to call you Miss Hunter McKnight?
Yes.
I'll continue to address you that way then. All right. I did read your objection, Ms. Hunter McKnight, to the PPO that I signed in favor of Ms. Gardner. And it essentially says, as I understand the situation, she was a supervisor. She terminated you at the workplace, and then you posted about that termination online and communicated with some friends of yours that are family members of hers. And I think, well, let me go over the allegations that she states, and then I'll figure out, and no one, I'll just note, it provided me with copies of the messages. However, Miss Gardner did indicate in her application that some of these, it sounded like she was quoting them straight off of social media. So, and the first thing she indicates, and she does indicate that during that time there were 33 missed calls from a blocked unknown caller between February 18th, when the termination occurred, and continuing, I suppose, up until the date she followed the order. Have you been calling her, even though she may have blocked your number, Miss Hunter McKnight?
Rossi. No, I don't even know her outside of work besides being a supervisor. I don't have a number to contact her. And also my lawyer has a contact from my phone company. I don't call anybody 30 times in a row. So like I said, I'm suing them, and all this is in paperwork and with the EEOC, and it has been filed already. So she's doing it in compliance to that. It's just retaliation. My lawyer simply told me to say that she put all these things in false pretense just to get a PPO.
All right. Well, how about now? Here's another one. It says, also contacted me personally through my Facebook Messenger. And so this is her speaking in this case, indicating she knows my sister-in-law, that the world is a lot smaller than I think, that she knows where my kids go to school at Granville, and that she hopes life spares me and my kids in treating me kindly. I guess that one is not
Say that I sent
particularly.
you the message of what I said, and she reworded what I said. My lawyer said, take a look at that carefully at the end. I said exactly the opposite. I said, I hope life didn't treat her the way she treated me. So she can't read, I guess.
Okay. Well, and I mean,
I have the copy here too.
all right. Well, here's the question. The next one here says, and this indicates same message again, so I'm going to assume this is Facebook message, indicating that she knows everything about you. Knows everything you say about me and do at work is being reported. And then again, in quotes, move out of town, get a new job. You can't walk through Walmart. And then the terms bad, fake, ass, racist. Did you make those comments on
No,
your
sir.
messenger?
No. Only certain comments that were made are on the public posts that were there, and none of them refer to that.
Okay.
There are a lot
Well,
of her
the
prior employees
one
that she was upset about, that she was reaching out to afterwards, crying about, saying that she was being thrown through the mud. No, sir. Never made any of those comments, and I don't know who would have made those comments. If they did make them, somebody made them for me. Maybe someone else she mistreated. I don't know. I
Okay,
didn't tell
but
them to do
you're
it
denying that you sent her messages that
at
said
all, except
that.
for what I've shown you on the paperwork, on the pictures. where she misworded what I said.
Did you send pictures of the posts with your?
Oh yeah, I went and gave everything in.
Okay.
Of her reaching out to my friends.
Yeah, I don't have those open to me here.
They're all.
Then, let me look at this here.
So like I said, she's been texting my friends. I put that in there too. She's reaching out to my people, arguing with them about how they feel towards her in their prior employment. They're agreeing with me, which the lawyer has as well, which is being used in the lawsuit. So, I mean, I was expecting this to be handled with the lawsuit. I don't need any. Why would I contact her? I certainly don't want to mess my money up. So it's just ridiculous. It's just retaliation. And she's also doing it because I work for the state in adult foster care. And I also took one of their clients from the hospital who doesn't want to be there anymore. And I work with her at home. So she's just really trying to do that so that she can't go back to Trinity with me, which we're not using Trinity anyways anymore. So it's really just nonsense. I only need their PPO removed because it's inaccurate. And she did it on false pretenses.
All right, well, I'll take some testimony from Ms. Gardner, and then I can make a ruling on it. So Ms. Gardner, if you would raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth? And I can't hear you, Ms. Gardner.
Can you hear me now?
Yes, I can.
Okay.
All right. Yeah, very good. Thank you. And, I quoted to you out of, what was the application for the PPO. Do you have any documentation, screenshots, et cetera, of those messages?
I do.
Okay. And do you have them in your possession now, or would you have to submit them to the court? How are you going to handle that?
I could have them in my possession just on my phone, but I could also submit them. I provided them to my HR through email that I could pull up as well if necessary.
Yeah, I think I am going to need to review those. And I guess probably even more important, how do you know for certain those came from Miss Hunter McKnight and not from, someone else who maybe, was just hearing about the case online, after Miss Hunter McKnight posted her claim that she was terminated for discrimination?
Yeah, sure. So in my appliance for the PPO, I did indicate that I have no proof of those phone calls being from Miss Hunter McKnight, as it's from a blocked number. It was simply coincidental. Felt like it started occurring at the same time, but I had no proof of it being her, which I indicated. The messages that I received came to me through Facebook Messenger directly from Chastity Hunter McKnight's account, indicating the exact quotes that I did say, inclusive of you don't know the type of person I am, that she does hope life spares me and my children, from being treated that way, that she knows where my kids go to school. And more so escalating and coming to my place of employment after her termination was really when I decided to move forward with the PPO.
Okay. Well, and now did she actually ever, and I guess the question
Can you
is,
ask her why she stalks me right
well,
here?
hang on, Miss Hunter McKnight. I don't need, I'm going to just hear from Miss Gardner now, and then I'll give you a chance again. But let me go back to Miss Gardner. Do you know that she actually came to the workplace?
I do. I received an email from our director of security indicating that she presented to Trinity Health on February 25th to our Howenstein building and was given a no trespass from GRPD when she refused to leave the premise.
Okay, so you didn't actually see her. You were just kind of alerted by security that she came onto the premise. And part of her explanation, as you understand it, was she thought perhaps there were pictures of her posted around and, kind of do not let this person, like a wanted poster. And that was not the case, correct? Is that, you have to say it out loud so I can record you, Miss Gardner. We do everything.
No, that there was a photo put out by our security department because she was calling and escalating, voicing that she was going to come to work.
Yeah.
And so our security officers often, when they feel that there is a potential threat, and this is for all members of the community, visitors, family members of patients, previous employees, They felt that they should put a bolo or be on the lookout, as they did not feel that Chastity should be on the premise. I did not post that picture on my unit, and I have an email that I could provide to you indicating that out of respect for Chastity, knowing that she has friendships, family members who work here, I did not feel it was fair for it to be posted on my unit.
Sure.
But it does get shared at all entrances of the hospital.
Yeah, I see. And that's really more of a security function. Did you initiate that because of the volume of calls that were coming to you, or was it someone else because they were coming into someone else at the hospital?
I did not initiate that. In fact, when I was initially asked if I wanted to move forward with any sort of PPO or formal legal action, I denied it. But then, given that Chastity was calling the hospital and saying she was going to come, I was given notice of that and encouraged to be mindful and safe in case Miss Hunter McKnight were to escalate. I did not ask for the bolo to be posted or issued, but it is part of policy for our security department. And as I said, Dave
Yeah.
Kittle is our director of security that put that in place.
Okay, yeah, and in other words, you weren't the one to say, I'm on the receiving end of everything here, but rather someone perhaps at HR or somewhere else was engaged with Miss Hunter McKnight and put, the bolo or whatever it might be, order and videos out, but it wasn't you, and in fact, you took a step to not put it in your area because that's where she worked.
That is correct.
Okay, all right. No, I think I understand. And are you able to email to me the copies of the messages that you're alleging are from Ms. Hunter
Yes,
McKnight?
I
Okay.
can do that if there's a good
Yeah.
email.
Yeah, why don't you email them to both Lisa and I? I'll give you mine is J Rossi at Kent County MI, all one word, .gov.
Okay.
And I think Lisa's is lisa.baird, also at kentcountymi.gov. Did I get that right, Lisa?
You did, and it's
All right.
BAIRD.
Yeah.
Okay.
If
Thank
you would
you.
just email those to me and you're saying I can look at those and view them and say, these are going to be obvious to me. They are from Miss Hunter McKnight's account and that they label you. I mean, I think the term you used was racist in there. Am I going to see that language in the posts?
Yes.
Okay, directed at you specifically, not Trinity's racist or their policies are racist, but rather you individually, Miss Gardner, are racist. All right. Okay.
Yes, you'll see both.
All right. Let me bounce back to Miss Hunter McKnight. Miss Hunter McKnight, I'll review the submissions that I'm going to get from Miss Gardner. I mean, assuming they say what she said, that first one you said that you put on there, Miss Hunter McKnight, that said, I hope you and your family, don't experience hard times. I don't necessarily have a problem with that, but when you start calling someone racist, that certainly moves into the category where it could be considered harassment. And then, if I put
Do you want me to read it to you?
Yeah, go
Because I
ahead.
have it here. You should have it because I came down there and this is attached to the PPO form. You should have everything I have, including her sending these kind of messages to my friend. This is Caitlin texting my friend, a former employee that was on my post commenting against her. She's reaching out to my people. This is another person here. And I'll read you what she says. Yes, I was sitting here and here comes a message from Caitlin. I'm like, I quit in October. Why are you even messaging me? So Caitlin's reaching out and this is what she said. I wanted you to know that what you're saying about me and Kelsey as I texted you, and I saw our entire text thread dating back to 2023. It's crazy through all of this how helpful I was accommodating you, how I was more than willing to remove points, adjust schedules, switch stuff when you had family stuff come up, which this is where the racist comes in. I was the only Black person on the floor for 10 months. And when she asked to accommodate any of my points or do anything for me or to be helpful, absolutely not. She's very much so racist. This is discrimination I was dealing with for 10 months that I was complaining about that she did not raise or escalate to HR. So let me get back to what she said. I was willing to switch stuff when you had family stuff come up, move you days to the unit needed as was simply 0.3 FTE commitment, whatever that means for her job. with working every third weekend, which is what all day shift does outside of those in school full time. We had a super open dialogue about this and offered to accommodate you however we could. If you go back through all of our messages, all I did was try to help you and support you. My name is being smeared through the mud, and you're joining in on it. Loving the horrible comments people are saying. I'm genuinely asking, did you actually hate me that much? Did you actually think we didn't support and accommodate your exact schedule you needed? Yes, they do, and they do feel that way. And these are things that people were leaving on the comments that she has no business, my lawyer said, reaching out to them, mimicking them, questioning them, or anything. Their former employees and her as a supervisor or anything like that is in trouble right now with her people. I'm suing her. I'm suing the boss, that Mike Hardiman, and I'm suing Trinity as an organization, all individually. So I
Right,
don't
well, and
know
of course,
how we're
that's
going to
all
do this.
separate from what we're.
She's lying. I mean,
yeah, I mean, I get it,
my
but I
lawyers,
mean, I
I'm
guess
gonna
my
give
thing
him this
is,
too,
well,
so he can see.
if you use the term racist in talking directly to her, and then
Let me read what I said to her, because I
yeah,
don't
let me
think I
hear-
did.
Yeah.
Let me get that, because I think
Okay.
she's putting words in my mouth. I was nice to her. I told her basically that her husband's brother's sister-in-law, her sister-in-law, is one of my best friends from high school. We graduated. I sent her pictures, and I told her basically, you come from the same type of world I do. I don't know why you're being so racist, so discriminative toward me at work, basically is what I said. You treating me different, and you're living the same world I do. She literally lives no different type of life I do. I have a house. She has a house. She lives not far from I do. We all live in the same area. We all shop the same stores. Why treat each other different? Is what
Well,
I
do
said.
you have the quote? I mean, I
Yeah, I'm
can't
gonna read it right
decide.
now. I'm going to it. I
Yeah.
have to get in my messenger.
Okay.
I don't write her. I don't contact her. She watches me every day. Is what I was also wanting to bring up. This is not cool. She's a non-follower in my every time I go on my story, she's in my stories. Or she's on the people you may know, which means she's watching my page. And this is proof right here. Her name's in it. This is my story. So I gave you that picture too. Don't stalk me and don't cut me off. Thank you. I'm talking to the judge, not you. Bye. I don't want to talk to you. Pay me. Thank you. You couldn't come up with 150,000 by the May 8th. You talk to the judge. Don't talk to me. Talk to my lawyer.
All right,
Bye.
just give me the quote, Miss.
Yeah, I
Hunter.
will. Tell her don't talk to me. Thank you.
Go ahead.
So I want you to see it before I read it. To Caitlin Gardner. It says, Caitlin, you see, when I do some looking up, one of my best friends is your sister-in-law. I said, it's such a small world, but like I told you, like I told her, I'm sorry, I don't appreciate how you lied in my face and retaliated against me for complaining about discrimination. I did not say she was racist. Since I don't work at the job anymore and they always watched me on Facebook, and remember, that was okay, you said. So here, I looked you up, knowing that's okay. Because when I was at work complaining and saying that these people were stalking me, looking me up while I'm working and coming up in my views, she said it was completely okay. Maybe they were interested. So I consider it the same for me. Absolutely. I said, I figured why not hit you up on your Facebook, just like you tell me that the world is a lot smaller. I said, I mean, to tell you that the world is a lot smaller than what you were thinking, and you're not different from me, and nor either any of the Caucasians at that job, except I'm not a hater. I'm not afraid to see someone coming along trying to do good because of their skin color. I said, your husband's sister is one of my best friends from high school prom, and so on. I said, I've shared what type of person you are with her and the way you guys treated me. In fact, you sat there and listened to me for months. You let it ridicule in your head. You never brought it up to HR or anybody made it urgent to the issue that you really wanted to handle, like you told me. You're disrespectful for playing in my face. And the fact that you wish me nothing but luck when your son goes to school with my little cousins and plays sports, would you like for someone to treat him that way? The way you guys did me? And would you like for him to complain and someone never take it serious? Do you realize how small of a city that says? Do you realize that I'm a great person? When you fuck with me and you rub me the wrong way or not treat me equally, I'm going to speak on it. I said, and you have done that. You tried to play in my face in front of that African-American man, the one who's fired me, I'm also suing as an individual with the Ray-Ban glasses on that I did not give okay to, and lied on me about attendance, so on. After you lied, you told me you were trying to figure out how to fix it. You're sorry, and I'm sure you wouldn't want anyone to have your kids being treated that way. And I saw her pictures of me with her sister. Me, the black girl, standing there with her people. Come on now, man. I didn't tell this lady anything. The second message, I said, see, you really ought to think about how you treated me. You don't really know me. You don't know what type of people I come from. I tried to explain what you sat there and said went against me, and you should have been trying to listen to me. That's your fault. You don't know who I am. You never gave me a fair opportunity with anything in that job, and I hope that life spares treating you and your kids the same. Literally, I didn't tell her anything except I hope they don't treat her like that. They treated me dirty for 10 months as an African-American girl, the only one on the floor. And she sat there for months listening to me cry in her office at times even, and never brought it up to the proper authorities above her in HR. Told me they
Well,
were
I think
always
the
busy
key
for
thing is
4
that
months.
That's all gonna be sorted in the discrimination.
In the lawsuit. So why do we have a PPO? I didn't tell her anything. I just read it to you. What did I threaten her
and it
with?
does
Or say
not
wrong?
that,
Nothing. She
no,
doesn't like it. Oh, well.
Well, but if you did call her a racist, that would be, I think, the part of it that would cross into. But you're saying you didn't do it. She's going to send me the documentation. What I'll do is I'll review the documentation, then I'll issue a written order on it after this. In the meantime, however, the PPO will have to stay in place until and then when I issue my order after reviewing the emails or the documents that I'm sent, then I can make a ruling on it. But in the meantime, it'll have to stay in place. Miss Gardner, anything to add to that? Have you sent me those documents?
No, I have not. I was waiting till the end of the call, but I can
Yeah,
send them
that's
to
fine. Yeah, you can. Yep. If you would just send them to me and I'll make a written order after I review the documents.
That sounds good. I will do that.
All right. Thank you both for appearing and speaking today. And I wish you both a remember the PPO remains in place, so there should not be any Miss Hunter McKnight, you can't reach out and try to contact Miss Gardner. And of course, I always say PPOs aren't mutual and that it doesn't prohibit you from doing anything, Miss Gardner, but I do expect that a person, when they're protected by a PPO, they use it as a shield and not a sword to poke the other person. So I expect it to be politely acknowledged by both parties. So with that all being said, we are concluded for the day. Thank you.
Thank you.
Judge Rossi, just impeccable professional, unfaltering in his mannerisms. He's just, Rossi is the bossy. That's exactly right. Oh my God, my chat crashed halfway through the stream and now I don't have it. Let's see if I can do this right. I did it right. Hey, look at that. Ladies and gentlemen, that is all I have for now, but there's more to come. 8 p.m. tonight, Central Time. There is a Judge Ricky case that you will not want to miss. We are going to premiere it. It's about an hour long. All I have to do is get the song ready, and I'm doing it this afternoon. So be looking for that premiere going up this afternoon, and I got something planned for tomorrow. I'm not going to tell you what it is yet, so you're just going to have to be subscribed and ready to look for that when it drops. It will be dropping sometimes between this afternoon and tomorrow afternoon. I'm not sure exactly when. We got premieres every weekend night, 8 p.m. Central Time, 9 p.m. Eastern Time. Chat will be live. I will not. Video will be uploaded. I can only go live like 6 times a week, y'all. Kind of crazy. Judge Ricky was on fire yesterday. OSG, you're right. Oh, I forgot. Hi! Are the dogs here? Oh, the dogs are in the backyard. I have company. So, thank you all for coming out. I need to go pay attention to my company, and I will say thank you, and let me before I roll, let me roll them credit. I gotta say thank you to Bob Smith, Barry Adams, and Great Granny. Oh my dear God, you people, Great Granny, amazing. Bob Smith, amazing. Barry Adams, you madman. Bob Smith, you madman. Thank you all so much for your donations that help keep the channel running. It is through contributions from viewers like you that we can do what we do, ladies and gentlemen. Thank you all lurkers, all my chatters, everybody who is here doing anything. OSG, great to see you, my friend. Oh my God. Hadn't seen you in chat in, well, I don't know. You were here not too long ago, weren't you? I don't know. I'm always lurking yours. Always. Every single time. It's just the way it is. I'm a lurker. I'm not even gonna lie about it. It's what I do. I'm creepy like that. Anyway, I am your lone Lafoosel, creepy lurker. I am in Mike's stream and OSG stream and all the streams, everywhere, all the time. I am there with you. But for now, I'm tired. I'm tired. I've put together tons of cases for this week, and we have now reviewed the final cases for this week. The rest of them that I have are going out at 4 a.m. and noon all week. The week coming up next week, and we will have live streams every single night of the week. 8 p.m. Central, 9 p.m. Eastern. Just like the premieres, you know. I'm your local Fussel. Thank you very much for being here. Out. Love you, Katie. Great to see you. Yell at correctly. It's her fault. You know it is. You still here? After I said bye 100 times, you're still here. I got nothing left. And it is technically Brecken's fault. So, until later tonight, go do something. It's a nice Saturday. Even if it's not a nice Saturday, go do something. Watch some TV or something. Eh? Be weather aware. Rhonda says hi. I say bye.